All rise. We will obey. Please be seated. Voice Vasiswa.
Thank you very much. We will now render our decision on the Ruto defense request. On the 14th of May, 2014, that was yesterday, the prosecution by email informed the chamber, the parties, and the victims' counsel that the prosecution had decided to withdraw witness 25, who was scheduled to commence testimony on the 16th of May, 2014. Today, the 15th of May, 2014, the defense of Mr. Ruto requested, in reaction to the prosecution's indication, the following. 1, the disclosure of the witness preparation note and the video of the witness preparation session that took place between the prosecution and this witness on the 14th of May, 2014. 2, a disclosure of expenses and benefits given to this witness since October 2013. And 3, disclosure of information on conversations, written or oral, between the VWU and the OTP in relation to expenses and benefits offered to this witness, beyond what had already been disclosed to the defense. The Ruto defense additionally requested that the witness, or rather that the OTP, not be given leave to withdraw the witness until the defense has reviewed the video of the witness preparation session. In the view of the Ruto defense, Article 56 of the statute may well apply, as the witness is here in The Hague and available, and there is no information on his unwillingness to testify. The Ruto defense, however, noted that at this moment, they only wish to view the information they have requested in order to decide whether they will meet the witness, amongst other things. At this point, the Ruto defense submits that the prosecution should not be compelled to call the witness they say is incredible. The defense for Mr. Sang does not oppose the withdrawal of the witness, but they state that this should be final. The witness should not be called or summoned in the future. As to the disclosure request made by the Ruto defense, the Sang defense does not object. The victims' counsel agrees that the prosecution should be permitted to withdraw the witness. The prosecution confirmed that the witness's withdrawal will be final. The prosecution confirmed that the expenses have already been disclosed to the Ruto defense, and there is no more to be disclosed in that regard. The prosecution also indicated that there was no further discussion that had taken place between the OTP and the VWU regarding expenses and benefits given to this witness, which have not been disclosed to the defense. In relation to the notes of the witness preparation session, the prosecution indicated that they will disclose the notes, although they did not indicate a date for doing so. The prosecution says that they have no difficulty disclosing the video to the chamber, but they object to the Ruto's defense for the video to be disclosed to the defense. In answering a question from the bench, the prosecution confirmed that the information, the video, information in the video may well be an Article 67 to material insofar as the witness is unreliable. But since the prosecution has conceded to this and will not call the witness, they do not consider that further disclosure is necessary. The chamber considers that the Ruto defense request is partially moot, as the prosecution has already confirmed that they will disclose the notes of the witness preparation session of the 14th of May, 2014. The prosecution has also confirmed that they have disclosed all information in their possession that is relevant to expenses and benefits to the witness, since there's nothing more left to disclose in that regard since October 2013. The prosecution further confirmed that to their knowledge, there has been no conversation with the witness in relation to business plans or things of that nature. The chamber will therefore only decide the question whether the video of the witness preparation session should be disclosed to the defense. By this decision, the chamber makes no determination now whether the credibility of the prosecution case has been affected by the mere fact of the prosecutor's request for leave to withdraw this witness, the circumstances in which that request was made, and the prosecution's communications and submissions thus far made regarding that withdrawal. But that is a separate question from the question whether the disclosure of the video should be made as a matter of the requirements of Article 67 sub 2 and Rule 77. In the chamber's view, the video should be made available to the defense under both Article 67(2) of the statute and Rule 77 of the rules, as it, quote, may affect the credibility of the prosecution case, unquote, or be material to the preparation of the defense. The chamber notes in that regard the extensive references to the evidence of this witness as made in the decision confirming the charges, as well as the prosecutor's pretrial brief. As well, The Chamber notes that in their communication, the OTP had indicated that the defense may consider consulting with this witness for purposes of their defense. Accordingly, the Chamber directs the prosecution to immediately disclose the video of the witness preparation session to the defense counsel. The Chamber will reconvene tomorrow at 9:30 a.m., at which point the Chamber will hear the Ruto defense finally on the matter of whether this witness should be kept in The Hague. The Victims and Witnesses Unit is instructed to maintain the witness in The Hague until further instructions from the Chamber. That is the decision from the Chamber.
As the court pleases, Your Honours. Your Honours, there's one practical consideration I should just raise at this stage, and that is with relation to the disclosure of the video material. The video material would, if we were to disclose it formally, would have to be copied first. We've taken instructions from our the technicians at the relevant unit, and they advise that this would take up to 5 hours to do. If the defense wants immediate access, my suggestion would be that we can make arrangements for facilities on the premises where the defense can view it immediately. So I'm in the hands of the defense as to which would be more convenient for them.
And that would be adequately covered under Rule 77, isn't it?
It would indeed. It provides for inspection of the material.
Mr. Ken?
Yes, Your Honour, I'm grateful to my learned friend. We'd be grateful for a copy in due course, but immediately we would take up the offer to view the original recording in the premises of the ICC. I'm grateful.
That is already the order of the Chamber. The order is based both on 67
Indeed.
and 77.
Indeed, I'm most grateful.
So,
Mr. President, just to be sure that we also get an opportunity to see the video.
yes, both defense counsel.
Thank you. Thank you, Your Honour. I'll make the necessary arrangements once the court stands down.
That brings us to the end of our proceedings for the day. Mr. Ken.
Mr. President, Your Honours, I wonder if there's one additional matter that the bench could guide us on. The order of the Chamber was that for the first 5 days of every new session, Mr. Ruto be in attendance. It looks like, of course, and in respect of that decision, he's made his diary, arranged his state commitment so that he would honour his obligation to the court. Your Honour, in the circumstance, I wonder if the court will give consideration to excusing him to go back to affairs of state back in Kenya, because it doesn't look immediately clear that we're going to do too much tomorrow apart from address you on the video itself. But Your Honour, I raise it now, but we're of course in the court's hands.
Mr. Khan, we will not be deciding that question now. There is a lingering matter of what we do tomorrow based on what you said. And that may tell us what happens next.
I'm most grateful. Yes. Thank you, Your Honours.
The Chamber will now rise.
All rise. We will wait.